Welcome everybody to the Health Law and Ethics Network seminar for August. My name is Associate Professor Paula O'Brien. I'm one of the coordinators, the directors of the Health Law and Ethics Network, and we warmly welcome you to today's seminar. I want to start by acknowledging that the University of Melbourne stands on the lands of the Wurundjeri people of the Kulin Nation and pay my respects to their elders past, present and emerging. So I'm going to move quite quickly to start the seminar today because we have such an interesting topic. So we're looking at abortion services in the US and Australia after the US Supreme Court case of Dobbs was handed down just a few months ago, really drawing attention worldwide and having implications for the US, but also giving rise to consideration around the world about what the case means for reproductive rights and abortion services in other countries. So we have three fantastic colleagues today who are joining us to present on this topic. We'll start with Professor Beth Gaze from the Melbourne Law School. We also have Ms. Casey Haining from the Melbourne School of Population and Global Health and Professor Louise Keogh, also from the Melbourne School of Population and Global Health. So we'll be recording today's seminar, and I'd like to start by handing over to Beth. Thanks, Beth.
Thank you. So what I'm doing is I'm actually just going to talk a little bit about the Dobbs decision itself, and in particular about its constitutional context, just to sort of outline exactly what happened in the US and what that means going forward. First of all, the decision was handed down in June. It was a challenge to a 2018 law of Mississippi, the state of Mississippi, that banned most abortions after the first 15 weeks of pregnancy. And what's been happening in the US is, even despite the existence of the precedent of Roe and Wade, the states that want to restrict abortion rights have been passing legislation restricting or trying to completely prohibit abortion. And those laws have always been challenged, and they've been taken up to the Supreme Court to be declared invalid because they're unconstitutional. So in this case, the same thing happened. The Jackson Women's Health Organisation, which is the sole abortion clinic in Mississippi, brought an action to declare that legislation invalid. And they were granted preliminary injunctions by the lower courts, who were following the Supreme Court precedent of Roe and Wade. But of course, once it got up to the Supreme Court, the result was quite different. So with Roe v. Wade, the Americans, we all say Roe and Wade, the Americans all pronounce the V. So with Roe v. Wade, in 1973, so nearly 50 years ago, the US Supreme Court held that there was a constitutional privacy right that protected women's medical treatment from government intrusion by legislation. So what it did was it prevented the government from legislating in a way that intruded on the private confidential relationship between the woman and her doctor. It was based on a privacy right, not a gender equality right or any idea of women's right to control their own bodies and reproduction. And again, it was not absolute, and it is balanced throughout the pregnancy with different interests that the court said the government can legitimately protect, like women's health and the development of prenatal life throughout the pregnancy. So Roe itself was based on a trimester model. So in the first trimester, the government could not intervene. In the second trimester, the government could intervene to adopt reasonable health regulations. And then in the third trimester, it could prohibit abortions except where they were necessary to preserve the life or health of the mother. That was refined in 1992 in the second decision, Planned Parenthood and Casey, in which the court said, look, yes, medical developments have changed the situation so that now we don't just measure pregnancy according to trimesters. We've moved the point of fetal viability earlier. And so now those classifications really depend on the development of the fetus. So it's really having brought the beginning of the third trimester back a little bit because the fetus can now survive from an earlier time. But the basic structure remained the same after Planned Parenthood. Now, in the Roe decision so the constitutional context, Roe relied on the 14th Amendment to the US Constitution. That was one of the amendments that were adopted after the Civil War, and the basic purpose was to ensure that the emancipated slaves were fully legally recognised as citizens of the US, because there was a huge fight in the South over whether the African Americans were actually given the same status. So I've included the text of just the first section there, and I just want to briefly mention two clauses. So one is the due process of law in red, and the other one is the equal protection clause. So equal protection is the one that people tend to be most aware of because it's the basis for US civil rights law and anti-discrimination law. And just by way of slight diversion, in 1896, the US Supreme Court upheld separate but fictionally equal accommodations, for example, train carriages and different entrances for blacks and whites and different lunch counters and so on, as being acceptable under the 14th Amendment. That survived until 1964, when it was set aside in Brown and the Board of Education, and the US Supreme Court said no, separate facilities are inherently unequal and they're in breach of the 14th Amendment. But Roe doesn't rest on that particular clause. It actually rests on the due process clause, and the court had over time developed a doctrine of substantive due process, which guaranteed substantive rights. And I'm not going to go into the detail of the reasoning because it's fairly complicated, but the court in Roe found a right could be implied from the due process clause that allows this privacy between the woman and her doctor. Now, why is it important to have a constitutional right? Well, what a constitutional right does is it limits the legislative power of the Parliament, or the Congress in this case. So what it meant was it prevented the federal government or the states from legislating to remove or infringe on the constitutional right to an abortion. But of course, the weakness of this approach is that it only depends on judicial decision making. And in general, the highest court of the land is extremely cautious about departing from its own well-established precedents, a 50-year-old precedent, because this whole idea of precedent is the basis of stability in case law. So it's extremely unusual to see something like this happen. And in fact, for many decades, courts used to say they couldn't depart from the highest courts used to say they couldn't depart from earlier precedents, but over time, they've accepted that circumstances sometimes require them to. So the new judges that were appointed by Trump joined some members who are already conservative on the bench. And in their Senate confirmation hearings, these new judges actually acknowledged the importance of stability and the dominance of precedent. But in fact, when they came to decide the Dobbs case, they decided to depart from precedent. So they overturned the Roe precedent. They said they have a different approach to constitutional interpretation. They said that you couldn't read the 14th Amendment due process clause so as to imply a right to privacy that supports this right to abortion. Their approach is an originalist one, and there's a lot of debate and a lot of discussion over what that actually means. But to summarise it at the most basic level is saying you have to understand the text of the Constitution as at the date that it was adopted. So they're saying you can't just use those words and adapt them to modern circumstances. And so they said, well, there wasn't a right to abortion in 1865 when those amendment, I think it was 1869, when those amendments were adopted. So it can't be a basis for right to abortion now. And of course, interestingly enough, historians in the US have then got into this debate saying, actually, you haven't established that there wasn't a right to abortion in the states at that time. So the debate continues in the US over these sorts of issues. But now that Dobbs has set aside the right under Roe, what does that mean? So there's no constitutional guarantee of access to or right to abortion in the United States. But that's exactly the same situation as in Australia. We have no constitutional rights or guarantees of abortion. The only thing we have is rights that are conferred by legislation. So, states have all slowly over the years legislated to remove criminal prohibitions on abortion, to regulate it as a medical procedure, etc. So why is it so horrific in the United States as a result of this decision? One of the things that having the constitutional right did was that it meant there was no need to actually build a coalition of support in favour of abortion rights. And because that coalition of support was not built, it means that a lot of legislatures are unsympathetic to abortion rights, and so they're passing laws to restrict abortion now that they're allowed to do it, rather than to actually support the right to abortion. So in the US, the problem, and of course the problem is, even though the US surveys indicate that there is, high majority support in the 60% for abortion rights, the problem is that the political system in the US is partisan. It doesn't have independent electoral commissions in a lot of states. Some states do, California, New York, so on, but many states don't. And so their electoral systems are subject to manipulation by the people in power, and there's a movement towards the governing bodies, the governing parliaments, not necessarily having majority support of the voters because of the gerrymandering of the electoral districts. So if the governments don't represent the majority of voters, then they can pass a restriction on abortion, even where the majority of voters may well support abortion. So what happens next? In the US, they're going to have to get themselves organised in those states to pursue some legislative rights to abortion. So there's no alternative for people there now. This is quite challenging because of the democratic deficits I've just outlined. So some states, clear protection for abortion rights and clear support for anybody from interstate who needs to access abortion rights. So the East and the West Coasts, the California, the New York, Oregon, Washington, all of those states support abortion rights. The problems are in the centre and the south, where anti-abortion legislatures have either restricted or want to further restrict access. And some of them have what's called trigger laws, which were in existence before Roe and Wade was decided, or may have been passed already, and they were expected to come into operation immediately. Now, some of those have been halted. So, for example, I think it's Minnesota that had a pre-existing law that restricted abortion, was invalidated by Roe v. Wade. The argument is now that it's revived after Dobbs, but an injunction has been granted to argue the point, to say, look, if it's been lapsed for 50 years, it can't be treated as a valid current law. So there's all sorts of interesting litigation going to occur there. Indiana, the first abortion prohibition passed since Dobbs was adopted last week in Indiana. So those central states are really moving as fast as they can to do that. But interestingly enough, in Kansas, there was a recent election where there was a proposal to remove a provision in the state constitution that protected abortion rights. And that was defeated with a huge turnout, much larger than you'd normally see in a primary election. So it looks like this actually might be the sort of issue that actually does activate voters. And so that will be interesting to see how that actually pans out in the different states. So people would have voted either because they want to protect abortion rights, or some people in the US, they have a very different attitude to government than we have. Some of them may well have said, look, government should not be interfering in the woman's relationship with her doctor. So as sort of a liberation type of argument. So that's, I think, where things are going in the United States. In conclusion, there is a lot of work to build support for abortion rights in those anti-abortion states, and we know in Australia that right has been done over many years by many people campaigning for abortion rights, and in particular by drawing on women MPs who've provided support, and certainly in Victoria, provided bipartisan support to regulate abortion here. The immediate effects in America have been disastrous because doctors are uncertain when they can interfere in a pregnancy, and particularly when you have laws like those in Texas that provide a bounty for anybody to report someone who may have been involved in anything remotely resembling an abortion. Doctors are saying to patients, look, I can't clear up your ectopic pregnancy now. I can't clear up your miscarriage now because, say, the heartbeat hasn't vanished, even though your waters may have broken and you're at risk of sepsis. We'll have to wait until later on. And I think those sorts of issues, sorting those out is going to be very fraught. So just to finish off with sort of a perspective on this, if you like, you know, my understanding from a feminist perspective of what's going on in the United States is this is a patriarchal backlash by conservative groups of men against the rise of women's rights and women's reproductive independence since Roe. So they're reasserting their control over children and women's reproductive capacity. Men, of course, are not directly affected by pregnancy or abortion. And I think it will lead to real problems for poorer women in those restrictive states who will have a lot of difficulty in terms of dealing with pregnancies and may well go back to backyard abortions and all the sorts of problems that we're likely to see there. The other side of it is, I think, just to reinforce that, you know, when we see those arguments about why we need constitutional rights in Australia, we need to be a little bit cautious about it, because what a constitutional right does is it takes something entirely outside the scope of the parliament. So it means it doesn't matter what the majority thinks, the parliament just cannot legislate in that area, and courts can find a right at the stroke of a pen, and equally, as we've seen in Dobbs, a right can disappear at the stroke of a judicial pen. So in a way, an attitude that Australia is often much more pragmatic about these things, and a lot of people would take the view that actually we don't really want to have constitutional rights in areas like this, because we would rather have the legislature, which is more democratically accountable, being in a position to regulate. So I hope that gives a little bit of background and some of the legal issues involved. Thanks.
Thanks, Beth. That was fantastic. Thank you very much. So we'll hand over to Casey now. Thanks, Casey.
Hi, everyone. My name is Casey. Discussing today the current state of abortion law in Australia and aiming to provide a brief overview. So in framing my discussion today, I'm really focusing on the legal framework, so the law in the books, so to speak, and acknowledging the limitations with that response in terms of how the law is intended to operate and how it actually operates in practice. There might be a dissonance there, and this is a segue into Louisa's presentation, who will be able to talk about some of the more on the ground issues. And just to, I guess, preface today, I will be framing my discussion largely in terms of women's rights, because it's overwhelmingly women who are intending to access abortions, but acknowledging that other gender identities can also access abortion. So in terms of an overview, I'll talk about the regulation of abortion in Australia, a brief overview of the decriminalisation, and then I will kind of hone in on particular aspects of abortion law, particularly gestational limits, safe access zones, conscientious objection. So in terms of regulation of abortion in Australia, as Beth had outlined in her presentation, we do not have a constitutional protection for an explicit abortion right. And due to constitutional constraints, abortion law is largely regulated by individual states and territories. There are some aspects of abortion that is regulated federally, for example, the Medicare and Therapeutics Goods Administration, but largely it's up to the discretions of the states. So what this has meant is that the liberalisation of abortion laws has largely been achieved through concerted advocacy efforts and individual states' law reform. And certainly with liberalisation, that doesn't necessarily mean that we will have an increase in access. And certainly, you know, we could argue that there has been progress, but still issues remain. And these issues are as a result of a number of legal and non-legal barriers. And of course, as indicated by the bold, I'm going to really focus on the legal barriers as opposed to the non-legal barriers today. So in terms of a brief overview of decriminalisation of abortion, so Australia has largely decriminalised abortion, exception Western Australia, where the abortion is still featured within the Criminal Code Act, but it is subject to the Help Act, where it's lawful up to 20 weeks, which I'll discuss. And also the criminal law still does have a role in regulating abortion, particularly when it's procured by non-medical professionals or non-health practitioners in some case, or non-authorised premises. So what we're seeing really is this transition though of moving abortion from a criminal matter to a matter of health. And this is kind of recognising that abortion is a form of legitimate healthcare, and it's really consistent with international and human rights norms. So even though we are regulating it as a health matter, it is still within that kind of medicalised model. So for instance, there are limitations as to who can provide abortions lawfully and indeed where they can occur. So what are the intended effects of decriminalisation? And I use intended there in terms of inverted commas because it might be the case that some of these effects have not been realised. But the idea is that decriminalisation theoretically will help reduce unsafe and clandestine abortions. So there is, and I refer to the Unsafe Abortion Preventable Pandemic seminal article that was published in The Lancet, which really talked about when we have these restrictive legal regimes, it doesn't necessarily mean that abortions will not occur. What it means is that abortions may occur in an unsafe manner. So kind of decriminalising abortion kind of moves it into a health matter where it can be kind of carried out. There is also other effects of decriminalisation. For instance, it reduces the chances of prosecution. It also helps build clarity around the lawfulness. So prior to abortion being regulated by individual states in legislation, it was a criminal matter, really based on a UK law, and we were relying on defences of necessity to make abortion lawful, which was subject to common law interpretation, which was ambiguous, arguably ambiguous at times. Another effect of decriminalisation is this idea that it will help to, by bringing abortion into the lens of a health matter, it really helps to reshape perceptions around abortion and reduce the associated stigma. So what is a kind of the legal framework in terms of abortion in Australia? So there is variations because, as I said, this is really a matter for the individual states and territories. So generally, states will have what we call these kind of gestational limits. And often states will make a distinction between kind of a permissible gestational limit and a later gestational limit, and the requirements slightly vary between those. The exception here is the ACT, where there's no prescribed legislative gestational limit. However, in practice, if you are looking for a termination post that 16-week mark, you generally have to travel to Sydney just because of the capabilities of the hospital rather than a legislative barrier. But with the other states, we have kind of varied gestational limits. So you can see they kind of range from 16 in Tasmania to up to kind of 24 in Victoria and Northern Territory. Now, most of these will be what we call on request if they're within the gestational limits. So that means that if a woman wants to access it, provided they give consent, that they will be able to access it within those gestational limits. Some states do have additional requirements, even if they're within those prescribed gestational limits. So for instance, in Northern Territory, you really, you have to be assessed by the medical practitioner to determine that it is appropriate in all those circumstances. So you are really subject to the discretion of the medical practitioner. Similarly, in South Australia, that there is a need for you to be provided with some counselling information prior to proceeding with determination, and there is informed consent requirements and additional requirements in Western Australia. Once we go post that gestational limit, however, other states start introducing additional requirements. And often this means that in order for the abortion to be lawful post that gestational limit, it will need approval from 2 specialist medical practitioners who generally need to determine that it is appropriate in those circumstances, and really taking into account when we determine whether it's appropriate in those circumstances, the medical, psychological, social and physical circumstances of the woman. Western Australia has a unique approach. There is 2 medical practitioners, but these are assigned based on, and these practitioners are appointed by the minister, whereas in the other jurisdictions, they're not necessarily appointed by the minister, but as this is not to preclude additional institutional requirements that Louise will talk to in a moment. So I guess what we are seeing here is that although we do have some of the states that do allow us to have abortion kind of on request, we do have this dichotomy between gestational limits, which means that we are treating abortion with a degree of exceptionalism post a certain post a certain gestational limit rather, and some would argue that this is kind of an over-regulation or overstep, or kind of undermining a woman's autonomy post a particular point. So in terms of, I guess, that's the gestational limit. So we are seeing here a framework where abortion is able to be accessed within particular gestational limits and subjected to additional requirements post a particular gestational limit. We've also, and that's certainly a progress from the criminal model. Another area in which we're seeing progress in the abortion law is in the area of what we call safe access zones. So these are kind of zones that operate around a health service or a premises that provides abortion, and they basically act as a buffer zone. And what they are really targeting is really these anti-abortionists or sidewalk counsellors, which target patient, staff and specific people who are entering an abortion clinic, and basically trying to often discourage that abortion. And in every jurisdiction, we are seeing safe access zones. So there is kind of a slight variation between kind of the radius and what kind of behaviour that they do, but generally they're the same. Western Australia became the final Australian jurisdiction to introduce safe access zones, and they did so last year. And of note, the Victorian and Tasmanian safe access zone provisions were subject to a High Court challenge, which was based on 2 appeals, one in the Victorian context and one in the Tasmanian context. And really that the question that the High Court had to consider was, are these safe access zones burdening political communication around abortion? So in Australia, we have an implied freedom to political communication, and the questions that the court needed to decide was, well, are these effectively burdening that freedom, and are they serving? And if they are they serving a legitimate purpose, and are they reasonably adapted and appropriate to advance that purpose in order for them to be constitutionally valid? And ultimately, the court did determine that these are constitutionally valid, and really recognising, I guess, that these safe access zones are really important in terms of protecting the privacy, safety and dignity of women, and helping them to facilitate access to a lawful health service. So when we talk about safe access zones, we're really considering 2 different kind of competing values. We're thinking about freedom of speech versus a woman's right to access a lawful health service. Another area where we see this kind of balance is in the context of conscientious objection. So conscientious objection is essentially a right provided to particular health practitioners that allows them to refuse to participate in a lawful health service on the grounds of conscience. And what we can see here is that every jurisdiction has a conscientious objection clause within their legislation, but the way in which it's regulated does vary. So I'm not going to go into the nitty-gritties of this slide, but essentially what we can see is that generally these applies to the individuals. However, we do have institutional conscientious objection permitted by legislation in Western Australia. And what we can also see is that the nature of duties imposed on conscientious objectors really does vary across states. So in some cases here, we for instance, we're required to disclose, health practitioners claiming a conscientious objection have to disclose their conscientious objection and also disclose that they are objecting on the basis of conscience, which is considered to be a really, I guess, a step forward in terms of respecting that woman's decision, because it's really communicating that the decision not to assist with the abortion is not on the grounds of a medical reason, but on the grounds of that individual conscience. And then in another manner, in terms of balancing the rights of a woman to access determination as well as the health practitioner, is to kind of facilitate access through the imposition of what we call a referral requirement. So the idea here is, well, if a woman wants to access a lawful service and a particular health practitioner cannot do so on the basis of conscience, that they should assist kind of facilitating that access. And the approach in which states have taken has varied. So we have some states that require kind of what I define as an active referral. So that means that they need to put the woman in contact with an individual practitioner that knows, that they know will provide that particular service, or put them in contact with a health service that they know will perform that service. Other states have taken a different approach, which is more of a passive referral, where often a woman will be given a set of prescribed information. And the idea here is not necessarily to put the woman in contact with an abortion provider, but providing them with a list of services that the idea is that they will be able to make a frank, impartial, and have a frank, impartial, non-judgmental conversation with one of those services. And then if the woman wants to proceed with an abortion, that might be facilitated, but of course that does cause delay. But as you can see, that there is kind of a different approach in terms of how the jurisdictions have approached this. Not all of them have introduced a referral requirement. Not all of them require that disclosure and institution. So you can see in terms of the calibration of women's rights as well as the rights of the health practitioners that we have kind of a differing approach across jurisdictions. So what we see here is, I guess, despite the tendency for Australian jurisdictions to liberalise their laws, there is a great amount of inconsistency. So this ranges from gestational limits. So as I noted to you before, you've got a gestational limit of 16 weeks in Tasmania, and post that gestational limit, you have introduced additional requirements in order to access an abortion. We've also got differences in approaches in terms of conscientious objection and the degree in which access should be facilitated. And arguably in some cases that this is kind of the approach of Australia is not necessarily aligning with international trends. So take, for example, the referral requirement. Certainly the referral requirement is recommended under the WHO guidance in terms of sexual and reproductive health and facilitating abortion access, as well as the World Medical Association and FIGO recommendations. And arguably in some cases that we are kind of over-medicalising this decision. So for instance, when we're seeing jurisdictions introducing additional requirements around when a woman can access an abortion based on consideration of the individual circumstances as opposed to merely a right to access within that, we see this kind of overlayer of regulation and undermining of women's autonomy. And so there is increasingly pressure of these states, particularly the states that haven't reformed their laws recently, so WA is an example of that, to kind of increasingly liberalise their laws to kind of align. But again, this is due to individual state and territory discretion. So it's likely that it will be the product of increasing advocacy efforts on that part. And I guess just to finish off, and in terms of the segue into Louisa's presentation, is that really the focus here is on law and some of the restrictions that law can impose. But law is merely one vehicle for achieving access, and consideration really needs to be given to other sources of regulation as well. So I'll hand over to Louise.
Thanks very much, Casey. That was wonderful. So we're on to Louise now.
All right. Yeah, thanks, Casey and Beth. Really great to have all that legal background played out really nicely. I'm going to talk more about the reality of abortion services in Australia now that we have that context so nicely described. So I'm going to talk about the landscape of our service provision, how we're going on access, and a bit more about this unnecessary regulation. I'm going to talk about institutional objection and some theory about why stigma persists when it comes to abortion. So there's been poor visibility of our service usage, like how many abortions are occurring in Australia due to a lack of data. With my partner, who's a statistician, Lyle Gurran, and Paddy Moore, who's here in the audience, I think, we published the first estimate of abortion rates since 2005, and we published this last year. And this was because there is data available through the Australian Institute of Health and Welfare and the Pharmaceutical Benefits Scheme. I'm not sure why it hadn't been analysed, but we put our heads together and did some analysis of this data, because I think knowing how many abortions are going on in Australia is really important to advocacy and just understanding. So this is the main table from our paper. So what we did is we plotted the number of surgical abortions for the whole of Australia by age group. So the Australian Institute of Health and Welfare collects data on all day procedures and hospitals, all procedures that are done, and surgical abortion is just one of the codes they use. So you can see here that the rate of surgical abortion is dropping, and that's because of the introduction of medical abortion. So we were able to demonstrate that there's about a 5% drop per year since 2014-15 in the number of surgical abortions being performed in Australia. And it's interesting there, if you look at the age groups, you can see the most common age group is 30 to 34, then it's 25 to 29, and then it's 35 to 39. And actually you can see the 20 to 24-year-olds, their rate of surgical has dropped probably the most. So they're obviously taking up their medical abortion slightly more than other groups. There's often a misconception that it's very young women having abortions, but that's actually not the case. So in 2018-19, there were 88,000 or over 88,000 abortions, including both surgical and medical. And so the rate we talk about with abortion is that it's a rate per 1,000 women of reproductive age. That's the number that we normally compare across countries. So our rate is 17.3, slightly higher than some other high income countries. Not sure that of the reason, except that possibly around our access to good education around contraception and also good access to contraception. The other interesting figure to consider is the proportion of medical to surgical. So our proportion of medical abortions is 23%. That compares with 39% in the US and 73% in the UK. So the UK have quite aggressively pushed women towards early medical abortion and made that the preferred option. I think in Australia, we're much more comfortable that women choose which option is best for them. But we also, having said that, we've had quite a slow rollout of medical abortion because it requires getting GPs on board to provide it in communities, and that hasn't happened as quickly as we might have liked. So that's a little bit about the numbers and the proportions. Now moving on to the type of services. So public abortion services are actually quite rare in Australia, and this is often a surprise to people. We're doing some interviews for a UK study at the moment, and this is not published, but one of the people I interviewed revealed that in most capital cities in Australia, there isn't a public hospital providing regular routine abortion services. And that because we are quite used to that model in Victoria, we have an extremely impressive abortion service championed for and run by Paddy Moore. That's not the case. It's not a routine situation in every state that they have that strong advocate in their hospital, public hospital, running this kind of service. So how do we get abortions? We basically rely a lot on fee charging private providers. So there was a survey by Shankar and colleagues that actually surveyed women to find out what they were paying for abortions in Australia. 1% had had an abortion free of charge in this survey. The average cost for a medical abortion is $560. Surgical abortions stagger in price, obviously, because they get more complex the later in gestation. So at 9 weeks, it's around $470. 13 to 19 weeks, it goes up to $1,500, and after 19 weeks, it's over $7,000. And then there's obviously other additional expenses that go along with a surgical procedure, and they were estimated to be around $150. So it's quite an expensive service in Australia, and this isn't the only model. So other countries have different models of service provision. Some countries that are offered all in the public service, some offer abortions entirely free of charge. So we don't necessarily have to have a system that's so heavily reliant on private players and charging fees. So moving on to access, there's now some really good services that can tell you where your abortion services are in your state. This screenshot is taken from the Children by Choice service that maps service providers in Queensland. And I've typed in surgical abortion. It looks okay. There's a few services around, but when you look in a bit more detail, the picture is not so good. Cairns, the very top service, provides MTOP to 9 weeks and surgical to 13 weeks. And after that, referral is to Brisbane. All of these blue services around the middle here, they're all local area health services. And although on they tick that they provide surgical abortion, when you read the fine print, it says you need to hold a healthcare card, have no ability to otherwise have a termination in the private sector. So there's really nothing between Cairns and Brisbane, where there are 2 Murray Stopes clinics in Brisbane and 1 in the Gold Coast. So there used to be Townsville and Rockhampton used to have services run by Murray Stopes. They've both shut down because Murray Stopes couldn't make them financially viable. So there's really very limited services in Queensland, and this is despite decriminalisation in 2018. So Victoria, we decriminalised in 2008, and there's been a concerted effort to increase services by our state government in partnership with very strong advocates for abortion services. So MAP is looking quite good. So this is from the 1800 My Options website, which is a public-facing website for women to go and type in their postcode, type in what they're looking for, and work out where the closest service is to them. So we have Ballarat and Bendigo surgical up to 12 weeks, which has been a long battle to get services into those quite conservative communities, especially Bendigo has been known as a very strong Catholic community. So it's great to see there's services there now. Albury and Wodonga have surgical up to 12 weeks. Mildura Base Hospital doesn't say what kind of details about their service, but they're listed on the map. And the government has just announced more sexual and reproductive health hubs for Shepparton, Warrnambool and the Latrobe Valley. So these are really targeted funds that the government has put into trying to get these hubs that may not necessarily provide surgical abortion, but they'll facilitate much more access and hopefully at least be offering medical abortion in communities. When you type in after 16 weeks gestation into the 1800 My Options site, you only come up with 3 services, and these are all in Melbourne: the Women's, the Austin and the Fertility Control Clinic. So yeah, although we do have more services, it still gets very light on at those later gestations. So moving on to thinking about unnecessary regulation. Abortion is legal at all gestations, and post 24 weeks requires the approval of 2 doctors. So that sounds pretty straightforward if the abortion is really needed. But in reality, hospitals that offer an abortion after 24 weeks generally require cases to be presented to a committee for assessment, and that committee will determine whether or not that abortion can go ahead. This is not stipulated anywhere in legislation, so this is an added layer of regulation that hospitals impose on abortion service provision. There's very little information about these committees in the literature, so we embarked on a study. The team is down the bottom there. You can see Hilary Bowman-Smart, Casey, Anne O'Rourke, Julian Zavalescu and Lachlan de Crepney. And we interviewed 27 healthcare professionals involved in a committee in a hospital to find out why these committees exist, really. And this paper has been under review for about 8 months. So I'm going to give you some of the headline results because it may actually never get published at this rate. So the functions of the committee as described by members it had 3 functions, and the functions were all about protecting something. So the first function was to protect outward appearances, and they often referred to this as the Herald Sun test. So because there was a famous case that ended up on the Herald Sun, a late termination, part of that part of the job of this committee is to really think about what sort of reputation the hospital would have if this became public, and also that if it did become public, that it would be clear that it had gone through this kind of committee and had been thought through, so that it isn't just resting on the decision making of 2 doctors. The other function was to protect the inward functionality. So rather than looking outward at the community and what they think of hospitals and abortion, to look inward and think, well, can we do this abortion at this time in this hospital? They really were thinking about the psychological well-being of their staff and the personal reputation of healthcare professionals. So it was to give the doctors who may be performing the procedure the backup to say, we're supporting you as an institution in doing this particular procedure, to make sure midwives aren't going to get overwhelmed by too many cases in 1 week, to really make sure that everyone who's going to be involved is comfortable and happy with that procedure taking place. And the final function was to protect service users. They saw that if this service wasn't done to the sort of highest standard possible, that the service could go. And we do see situations where a service is offered and then that service is removed for whatever reason. So they saw it as the committee actually having an effect on ensuring the long-term viability of these services. But there's lots more data that we're looking at with these committees, and we will be hopefully publishing more about the ethical decision-making that goes on in these committees, and a whole bunch of other stuff. So really, really interesting work there. I wanted to talk a bit about institutional objection. So the last time I spoke to this group, I think I presented a lot on individual conscientious objection. So I wasn't going to go through that again, but we're starting to collect a lot more information about institutional objection. And that's been from 2 main sources. The first one is that unpublished research about the late termination of pregnancy committees, because we were able to really understand the impact of an institutional objection on women diagnosed with a fetal abnormality during pregnancy. So we spoke to clinicians who work at a hospital that has an institutional objection to abortion, but is also a hospital that provides maternity services and genetic testing for fetal abnormalities. So we found out quite troubling information about what happens when a woman is diagnosed with a fetal abnormality at a hospital with an institutional objection, is that she will be transferred out of that hospital if she wants to proceed with a termination. And it's done in the most caring way possible, and the clinicians involved are all incredibly thoughtful about managing that patient's care. But I guess it raises issues about that hospital's responsibility to let women know that this might happen if the fetal abnormality is detected, and really whether the community would be comfortable knowing that a public hospital that's providing a mainstream service, that this is how they operate. So I think there's some really interesting issues there that we will be unpacking further. The other way we've been looking at institutional objection is through an unpublished review of the literature, which is being led by Bronwyn Myrna, and you can see the authorship lists down there. And once again, Julian Savulescu and Lindy Wilmot, who are on the ARC grant that we have on conscientious objection, are on this paper as well. So this was looking at what do we know about institutional objection from the literature, and Bronwyn did a fantastic job summarising what we know just from the literature. And we definitely can see that there is a lot of institutional objection across different countries. It's quite common in the US, and it does obviously impact not just abortion, but actually I think someone alluded to this earlier, the clinical management of pregnancy complications and miscarriage. So unable to use certain drugs, needing to ascertain non-viability of the fetus before managing a miscarriage. And that this has resulted in a death of a woman in the US previously. And we don't know how often that might happen, because that's not best medical care. Best medical care is to deal with the woman and not wait for the fetus to die if it's going to die anyway. Being unable to provide tubal ligation at the same time as managing an ectopic pregnancy, and clinical decisions just being delayed or impeded because of these hospital ethics committees. But the other thing we found is that both religious and secular hospitals engage in institutional objection. So it isn't something that is only sort of the traditional, what we think of traditionally as the Catholic hospitals. They weren't the only hospitals engaging in this. So there may be other reasons that hospitals don't want to provide this service, and institutional objection seems to be something that is freely accessed. And there was evidence that because in some places it isn't sort of considered legal to have an institutional objection, staff would be asked to sign an individual conscientious objection form before commencing employment. So even though they would say, the institution could say they weren't claiming an institutional objection, they could claim it by proxy by saying, well, all of our staff have an individual conscientious objection. So some worrying behaviour in that space as well. Now, finally, I just wanted to mention abortion stigma. It's just such a persistent problem. Many of us hope that decriminalisation would start to undermine the stigma, but it hasn't really happened. We widely acknowledge that stigma is enacted in social relationships. It's linked to notions of power, and it's a mechanism for exerting social control by sanctioning some behaviours and not others. Kumar's done some really interesting work and just talks about abortion. It's a socially disordering act because it undermines this idea of womanhood and motherhood and all of those things that that some in society want to keep going strong. And abortion flies directly in the face of that. Therefore, it is stigmatised. And the anti-abortion discourse has emphasised the status of the fetus, while pro-choice discourse emphasises women's autonomy. And it does seem that the anti-abortion movement, despite representing such a small proportion of the population, have been politically influential in managing to dominate this sort of popular representation of abortion. And it's really surprising, I think, that we haven't made more progress. So one interesting thing that I'm interested in exploring further is the prevalence paradox around abortion, because it is such a common procedure, which is why I started with the numbers, 88,000 or more abortions per year. And yet the silence around it, the women undergoing abortions generally don't speak about them, often even in surveys might not admit to having had an abortion, so that the silence kind of perpetuates the stigma, and then it's this sort of mutually reinforcing cycle of silence that is perhaps something that we could start to address by being more open about the data that we can access. Just finally, positive signs in Australia. Canberrans have access to free abortions now. Fiona Patton's pushing to stop institutional objection, despite the fact that that bill probably won't get up. The fact that it's being talked about is a really positive thing. So overall, I'd say progress in Australia is continuing despite the regressive moves in the US and our current research. We've got lots more to do. We're looking at the need for legal reform, existence of evidence in the literature. We're doing a global policy review. We're doing an ethical analysis of all the different options for managing conscientious objection. And we're about to start some data collection with all the stakeholders in conscientious objection as well. We aim to propose a new model and test it with stakeholders, and I'm seeking funding to do some research on stigma as well, and whether data can be used to address stigma. So thank you, and hopefully we've got time for questions.
Thanks very much, Louise. So thank you to Beth and Casey and Louise for 3 really fantastic presentations that actually came together so nicely. I think we don't have time for questions.
Oh,
I'm so sorry. So we're just 1 minute to 2. So I think
Okay.
I won't open it up, because I think what will happen is that we'll have our question and we won't really have time to answer it. But I hope for everybody who's been here today that this has been a really fantastic seminar where you've learnt things about the US and Australia, and that you've got to see some of the really excellent research that's been conducted between the Melbourne Law School and also the Melbourne School of Population and Global Health. If people have questions, I hope it would be okay with the presenters if people got in touch with them directly. So that might substitute a little bit for the short question time that we were going to have. But the thing is, the presentations were so excellent that there was just so much to talk about. So thank you again to our presenters, and we look forward to seeing everybody at the next Health Law and Ethics Network seminar. If you haven't signed up to our mailing list, please do go onto our website, and there's an easy place on the homepage of the network to sign up and to get information about things that are going on. So thanks everyone, and have a good rest of the day.
Thanks for organising, Paula.
Pleasure. Thank you.